Hey everyone, and welcome to The Explainer. If you have a test or an exam coming up on the law of evidence, you are in exactly the right place. Today, we are building your ultimate comprehensive exam masterclass. And I mean it. We are covering every single concept from our source material today. Literally nothing is getting left behind. We're going to break down those tricky concepts, translate the heavy Latin terms, and use real, practical South African examples to help you lock this into your memory. So, let's get into it.
Okay, here's our mental map for today. We've got 5 key buckets: foundations of evidence, admissible evidence categories, inadmissible evidence, unconstitutional evidence, and finally, the principles of natural justice.
Right, to really set the scene, I want you to imagine you're walking across the University of Johannesburg campus, getting ready to step into a strictly run courtroom. Now, in this room, you can't just say or show whatever you want. The law of evidence acts like the ultimate gatekeeper. It strictly regulates exactly how facts are proven. Every single piece of information has to pass through some really rigorous legal filters before a judge will even look at it. Let's hit Section 1, Foundations of Evidence Law, specifically the core legislation. Okay, crucial exam point right off the bat. Where do these rules actually come from? Well, in South Africa, our law of evidence is largely codified. That means it's literally written down in specific legislation. You absolutely need to lock these 5 acts into your brain right now. We've got the Civil Proceedings Evidence Act, the Criminal Procedure Act, the Law of Evidence Amendment Act, the Electronic Communications and Transactions Act, which everyone just calls the ECT Act, and the Criminal Law Amendment Act. Seriously, write those down, highlight them, memorize them.
Moving right along to Section 2, Admissible Evidence Categories.
So what actually makes it through that strict legal filter we just talked about? Well, let's look at the 3 main categories. First up, oral evidence. This is the most common, but its weight is totally dependent on credibility. Courts apply strict cautionary rules here, especially for single witnesses or young children. Then we have documentary evidence, like a will or a signed affidavit. Now think about it. You can't cross-examine a piece of paper, right? Plus, they're super easy to forge, so documents actually have less force than oral evidence. They require a witness to physically authenticate them, and they're subject to the best evidence rule, meaning the court generally wants to see the original document, not a copy. Finally, electronic evidence. Think emails, WhatsApps, voice notes. These are governed by that ECT Act we mentioned, specifically Section 15.3, which lays out the exact factors a court uses to decide how much weight to give that digital data.
Now let's run through a series of rapid-fire definitions. Think of these as your mental flashcards. First up, expert evidence. Normally, regular witnesses can't give their opinions, but experts are on a totally different playing field. Because they have specialized training, like a ballistics or fingerprint expert, they naturally know more about their specific field than the judge does. But, and this is a massive exam tip, so pay attention, the judge is absolutely not obliged to blindly follow the expert's opinion. At the end of the day, it is the court's opinion that decides the case. Next up is real evidence. This is exactly what it sounds like, a tangible, physical object. The actual murder weapon, the stolen TV, that's real evidence. But here's a fascinating twist. A person can actually qualify as real evidence. If the court needs to physically look at someone to guess their age or to inspect their injuries, that person's physical body is officially serving as real evidence. And closely tied to real evidence is a Latin term you absolutely must know: inspection in loco. In loco literally translates to in the place. This is simply when the court leaves the room and takes a literal field trip to the actual crime scene. Whatever the court observes while they're out there on site, that officially counts as real evidence. Rounding out our definitions, we have judicial notice. This happens when the judge just accepts something as a fact because it's universally known, even without formal proof. Like, nobody needs to call a scientist to the stand to prove that December 25th is Christmas Day, right? The judge just takes judicial notice of it. Oh, and for your exams, you also need to know about legal presumptions. Remember the 2 types: rebuttable presumptions, which you can actually argue against if you have new evidence, and irrebuttable presumptions, which are basically set in stone. You cannot challenge them. Now this brings us to a guaranteed exam question: the difference between direct and circumstantial evidence. Direct evidence is an eyewitness physically observing the facts. So I saw person A shoot person B. Boom, direct. Circumstantial or indirect evidence doesn't carry the same weight because it forces the court to make an inference. Imagine a murder happens inside a house. A witness says, "Hey, I saw person B climbing through the window that night." They didn't see the murder, right? They just provided circumstantial evidence, and now the judge has to connect the dots.
Okay, Section 3, Inadmissible Evidence and Exceptions. Let's look at the rules and the exceptions.
So what gets caught in the filter? First, character evidence.
You generally can't bring up someone's past just to say they have a tendency to do bad things. Just because a guy lied 5 years ago doesn't automatically mean he stole a car today. But it does slip through the filter in a few rare exceptions. It's allowed in sexual offenses or if there's a strong, highly logical link. It's also allowed in defamation cases, which makes total sense since defamation is literally a lawsuit about your reputation. Also, if the accused takes the stand and brags about their own good character, well, they've officially opened the door for the state to bring in evidence proving their bad character.
Next is hearsay evidence. You know this one. It's second-hand information. My friend told me that he saw. It is highly unreliable because the original speaker isn't in court, they aren't under oath, and you can't cross-examine them. But a court will look at 3 specific factors before making an exception. 1, the nature of the evidence. 2, the purpose of the evidence. And 3, the actual reason why the original person can't just come to court and testify themselves.
Then there's opinion evidence. Like we said earlier, standard witnesses just give raw facts. The conclusions they draw are totally irrelevant because, hey, drawing conclusions is the judge's job. But exceptions exist. Obviously, expert opinions are allowed, but it's also allowed if it's literally impossible to explain the facts without giving an opinion. For example, if a witness says, "The driver looked drunk," that's technically an opinion, but it's the only natural way to state that fact. And we also have privileged evidence. This is perfectly good, relevant evidence, but the law lets you hide it to protect a specific relationship. The big takeaway for your test here is knowing the difference between private and public privilege. Private privileges are things like attorney-client confidentiality, marital privilege between spouses, and the right against self-incrimination. Contrast those with public privilege, which is all about protecting the greater good, like state secrets or police informants. Make sure you can easily tell them apart.
Moving on to Section 4, Unconstitutional Evidence Rules, and specifically the Section 35(5) discretion.
So, what if the police literally violate someone's constitutional rights to find the smoking gun? Is that evidence automatically thrown out? Actually, no. Section 35(5) of the Constitution is a massive exam focus. It gives the judge the discretion to exclude that evidence based on a strict 2-part test. They can throw it out if, 1, it would lead to an unfair trial, or 2, it would otherwise be detrimental to the administration of justice. It's a really delicate balancing act, and you definitely want to reference the crucial South African case law here, specifically the cases of S.V. Sosi and S.V. Mthembu.
Finally, Section 5, Principles of Natural Justice. Let's look at the fundamental rules.
Let's lock in the 2 essential Latin maxims that govern every single courtroom. First flashcard, audi alterum partem. It literally translates to, hear the other side. This guarantees 3 things. You have the absolute right to be fully informed of the charges against you, you must get a fair and reasonable chance to answer those charges, and the tribunal absolutely must listen to both sides before deciding. Audi alterum partem.
The second big maxim is nemo iudex in sua causa. This means no one should be a judge in their own case. It is all about preventing bias. It demands complete, 100% neutrality. The tribunal can't have any discriminatory motives, and absolutely nobody on the panel can have any personal or financial interest in the outcome. Nemo iudex in sua causa.
So as we wrap up this explainer, I want to leave you with a question. When you finally sit in that courtroom, maybe as a lawyer or a prosecutor or even a judge, how will you balance these incredibly strict codified rules of evidence against the ultimate pursuit of natural justice? Learning the rules is just step 1. Knowing exactly when the exceptions apply is what makes you a true master of the law. Keep studying those flashcards, keep reviewing these concepts, and I will see you in the next explainer.